Hello friends, in the series on the income tax cases, today we will discuss the case of Deputy Commissioner of Income Tax versus BHAWNA Computers Private Limited. This case has been reported in 108 ITR Tribunal at page number 351 and the matter has been decided by Mumbai ITAT B bench. The date of the judgment is 14th September 2023. The purpose of discussing this case is that nowadays, as we see in our regular practice, that a number of the companies are being converted into limited liability partnerships. One of the major reasons for this conversion is that there is a lot of legal formalities for a company and it is very difficult to withdraw the money for the shareholders from the company. That is why the new entities are coming in the form of LLP and even the old companies are being converted into limited liability partnership. When a company is converted into limited liability partnership, the name of the company is struck down from the register of companies, and that too from the date the company came into existence. This concept is very important for the income tax proceedings. The reason is that when a company is converted into LLP, then the question arises that for the assessment of the years for which the company was in existence, can the department pass the orders in the name of the company? There is a case of Maruti Suzuki of the Supreme Court, which is a very celebrated judgment on this issue, which clearly says that if an entity does not exist, then you can not make the assessment in that name. There is one section, that is section 170, which talks about the succession to business otherwise than on death. In this section, the conversion of company into LLP is covered, and in that section it is written that up to the date of succession, you can make the assessment in the name of the predecessor and 1 year earlier. For example, in this case, the conversion took place in the previous year 15-16. So, for the 15-16 previous year and 1 year back, you can make the assessment in the name of the company, but not before that. The relevant assessment year in this case was that were assessment year 16-17 and assessment year 15-16. But the assessing officer also issued the notice for the assessment year 2009-10. So the disputed year was assessment year 2009-10. For this, when the assessing officer passed the assessment order for the assessment year 9-10 also, the CIT appeal deleted that assessment, and when the department went to the ITAT also held that whatever the assessment has been made for the assessment year 2009-10 in the name of the predecessor, that is in the name of the company, that assessment is not valid. Earlier the department has made the assessment under section 153C. So the submission of the assessee was that because no material, incriminating material has been found in the premises of the person on whom the search has been made, so ITAT categorically said that section 150C is not applicable, but since the tangible material was available with the assessing officer, he can go with section 147 read with section 148. But due to the section 170, the department cannot travel beyond 1 year back up to the date of the succession, and the assessment done under section 147 read with section 148 was not justified. Friends, this case is also a perfect example that sometimes we involve ourselves in giving the replies and do not take this ground that whether the department can do the assessment for that particular assessment year or not. So section 170 is very important as far as the conversion of company into LLP or a vice versa is concerned. This section is very important because nowadays a number of the conversions are taking place, and the department may issue the notice in the name of the predecessor. So first of all, look that whether the department can do legally under section 170 for that assessment year. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus BHAWNA Computers Private Limited, and this case has been reported in 108 ITR at page number 351. The matter has been decided by Mumbai ITAT B bench, and the date of the judgment is 14th September 2023. Thank you, friends.